the believers. In the same way, the temple of justice is not only the judges. The head of the federal military government was as good as law, that Babangida could be sitting in his bathroom. But in practice, ostensibly, there were still laws. In fact, when the military seized power on the 31st of December 1983, they enacted legislation that they hoped would enable them to try those elected during the Second Republic. Unfortunately, the relevant decree contained the words, "with effect from the 1st of January 1984, words which Justice Rosaline Omotoso, who was then the Chief Judge of Lagos State, which she held deprived the Buhari Idi Agbon dictatorship of the ability to charge any of those whom they had detained for any acts done before the 1st of January 1984. Of course, the decree writers in the Ministry of Justice immediately got busy and amended the decree to backdate it to the 1st of October 1979, when the Second Republic started. But as you can see, there was at least an attempt to enact laws. For sure, by the end of the day, those decree writers had twisted themselves into ever more ridiculous pretzels of legal drafting, as for example, in awarding themselves the right to detain people without trial. The military dictatorship purported to oust the jurisdiction of the courts to question anything, not just that was done, but even that purported to have been done under Decree number 2 of 1984, which was the State Security Detention of Persons Decree. In theory, this was because when everyone was being locked up anyhow, minor petty dictators were signing detention orders that were supposed to have been signed by Major General Tunde Idi Agbon. But you could not even base a challenge on the fact that a detention order had been signed by Captain Vindictive somewhere, locking up the girl who refused him a dance at the Christmas barracks party the year before. It was purported to have been done under the decree, and that was all there was. So what happens if we fail to accept or understand the basic principle that the temple of justice must be sacred? It means that we agree that arbitrary exercise of power is okay. That we accept the KBAC principle, where the word of whoever it is who's managed to seize power or to climb to the top of the greasy pole, that person's word is law. And if it changed from the way it was exercised yesterday or 2 minutes ago, well, that's just too bad. Keep up. Now, contrary to the do not question the Lord's anointed mindset that is common in this country, the fact that something is sacred does not mean that it cannot be criticized or questioned. One only has to look at the Psalms, 13, 22, 77, and 142, etc., to see that David did complain and question his God. So it's important to emphasize that our hope for a sacred temple of justice is not and should not be a bar to criticism. Since our temple is man-made or manned by fallible human beings like ourselves, it's only through criticism and questioning that we can drive improvement and draw a bit nearer to perfection. Indeed, the very fact that we have a system of appeals embodies the recognition of that human fallibility and capacity for making mistakes. The issue, however, is whether the questioning and criticism to which the Temple of Justice has been subjected in our present times, in our current system of civilian rule under the Constitution of the Federal Republic of Nigeria, has moved away from the goal of criticism that may leave scars in the drive to achieve improvement and towards the goal of simply inflicting scars. Indeed, with the ultimate goal of bringing down the temple, as that deprives the temple of its sacred character. Let's look at the kind of scarring that we've been seeing. There is, of course, the scarring that judges themselves have done in the Temple of Justice in Nigeria. Yes, of course, there's scarring that's done by others, lawyers, the media, the public at large. But however little direct evidence there may be, at least that an ordinary jobbing lawyer like me would be aware of, it would be naive to think that no judges have contributed to the scarring. Indeed, there have been examples, a few examples, of judges actually being convicted for judicial corruption. Those judges, however, do not include any of the judges who were victims of the so-called sting operation carried out by the Department of State Services starting on the night of Friday, the 7th of October 2016. The report of that event in the Punch newspaper of 9th October 2016 would have been darkly comic if it hadn't been a tragic statement about the anyhowness that attended the whole episode. And I'm going to quote from the Punch report. Quote, "A security guard and stewards who witnessed the operation at Dimba's place confirmed the incident to our correspondent. They said that the DSS operatives had no cause to apply force, as the judge had let them in without any resistance. Sources said that Justice Dimba complained after the departure of the DSS operatives that they, the security operative agents, left with a bag containing the draft of judgments which the judge was meant to deliver next Tuesday. The judge got to know of the presence of the DSS operatives at about 8 p.m. on Friday after he was alerted by his security guards. About 20 of them surrounded this house and that of Justice Ademola. About an hour later, they sought to enter the house and they were let in. On getting in, the judge asked for their search warrant, and they promptly produced one, which bore Justice John Nyang's name. The judge made them to realize that he wasn't Justice Nyang. And they produced another one, bearing Justice Ademola's name. Justice Dimba again said that he's not Justice Ademola. They promptly apologized that there was a mix-up, but they had instructions to search his place. They went ahead to search the place for about 30 minutes and, as they said, went away with the bag containing his judgments. I dare say that the expected chairman of this occasion could testify to the same anyhowness that was evident in the October 21 invasion of her own private residence, because again, the DSS came wrong address, it's just makes you a bit worried about the security of the nation. Now, Lee Oshundare's poem, My Lord, Tell Me Where You Keep Your Bribe, published a few days after the DSS raids, was a satirical reaction to discoveries thrown up by those raids. And those discoveries were described in the media as, quote, evidence-based reports of illicit keeping of huge amounts of ill-gotten money in hard and local currencies, in rooftops, and other ridiculous non-banking places. The opening stanzas of the poem are excoriating. My lord, please tell me where to keep your bribe. Do I drop it in your venerable chambers, or carry the heavy booty to your immaculate mansion? Shall I bury it in the capacious water tank in your well-laundered backyard? Or will it breathe better in the septic tank, since money can deodorize the smelliest crime? I won't go on, but you get the idea. And despite the failure to secure convictions after that October night of the long knives, the miasma of suspicion remains and hangs over the head of every judicial officer, tainting them all, the good and the bad. Yet to my mind, it is deeply unhealthy for us to approach the issue of judicial integrity as though it cannot be found, as though what was alleged, but ultimately not proven, against less than a dozen judges is what is true of all. Whenever these issues arrive, I recall one memorable day when I, just an ordinary non-silk legal practitioner, had a plethora of matters one day. One was a trial at the Federal High Court, one was a judgment, another was a ruling, and then we got a hearing notice for a judgment at the Court of Appeal in a matter that had not yet been argued. So I deployed my two juniors and went off to do the trial myself. I came back from the trial, which didn't go on, surprise, surprise, to find that my juniors were back with three decisions in my favor. The High Court judgment and the ruling, which disposed of the entire case, went in our favor, and so did the matter at the Court of Appeal. It turned out that I had not been served with the hearing notice for the argument of the appeal, but on the day in question, the Court of Appeal treated the appeal as having been argued on the basis of the brief of argument that I had filed. And on that, without hearing my spell-binding oral address, they had determined the appeal in favor of my client. These things happen. That's what's normal. You don't have to see judges. You don't have to know them. I was reminded of the remark made to former Justice Charles E. Archibald, which he related in his memoir, A Stranger in Their Midst, and I'm quoting him. I was warned of the unfortunate phenomenon of the corrupt always suspecting corruption in others by Honorable Justice Philip Namaika Agu. A further handicap is the susceptibility of even people of integrity to the notion of other people's avarice. They just love feeling and being regarded as ethically superior. And then, of course, there is the, quote, do not what I do, but what I say crowd. There's no honor or association among thieves where they are separated by hierarchy or status, unless, of course, by happenstance, they are sipping from the same bowl. As I said, despite the brouhaha that attended the sting operation, none of those arrested or trashed in the news media for allegedly having large sums of money in strange places was eventually convicted, or if there was any conviction, it was quashed on appeal. And yet even I have heard credible reports that speak of judicial corruption, nor, as might be thought, have I heard such tales only from members of the inner bar. I'm reminded of a former junior of mine who was having a really difficult time in a case. And at last there was a chink of light and there was a ruling in his favor, not dispositive of the whole matter, but he wanted to get a copy of that order and he kept on going and they wouldn't give him his certified true copy. And eventually the registrar said, why don't you see the judge and go in and ask him. And so he went in and saw the judge, and the judge said, Mr. So-and-so, signed the order and gave it to him. And so this young man said, oh, my lord, thank you very much. Now this young man comes from the eastern part of the country, and the judge was the judge of the Lagos High Court. And so he looked at him and said, is that how they say thank you in your part of the country? 2 years at the bar, this young man. He said, luckily it was Christmas, so he was able to put together a hamper and deliver it to the judge. And he agonized with an envelope of 2,000 naira, which in those days was quite a lot of money. Took it, and then the registrar said, oh no, the judge is out, but you can leave it. And he said, well, there was something. He said, no, we know all about it, you can leave it. So he left the envelope with his 2,000 naira, and when he said that after that, for some time in that case, it was like going into the sunlit uplands. The judge was so kind to him. So it's not that we don't hear about these things. I should again refer to former Justice Archibald. When he was posted to the Federal High Court at Enugu, he expressed surprise, and I'm quoting him, that holdovers from my Enugu campus days were not about to become sociable, not even some pretty close former pals. They kept their distance. Well, my immediate reaction on reading that was, but that's how it should be. Or rather, that was how it used to be. To accept the role of a high court judge used to mean something of a severance from one's former life. I spent 12 years in the chambers of G.O.K. Ajayi and Company, and in all that time, I saw only one high court judge visit him in the chambers as a friend. That's not the situation now. And the creation of the rank of Senior Advocate of Nigeria has not improved matters. Rather, it's as though to take silk is to be admitted to an inner circle of persons with whom high court judges or justices of the Court of Appeal or Supreme Court can mix freely. Indeed, it's even a question whether one can attain the rank without mixing with judges. In the days when I used to apply for silk, a law school classmate of mine who had taken silk advised that I should just, pop in and see one or two of the justices of the Supreme Court whenever I had a matter in Abuja. I should pop in and ask if there was anything that I could carry to Lagos for the Supreme Court justice, or some similar pretext. Nah, I didn't do that. That's not the only reason why you don't see me with SAN after my name, but I felt that it could be okay for him as a gentleman in trousers of the bar, but would not be a good idea for me. Many on the bench today do not seem to feel the need to separate themselves from the rest of the world. Indeed, just last week, the People's Democratic Party had cause to criticize the newly elected governor of Benue State, who's a Reverend Father, for traveling to Plateau State to attend the one-year remembrance mass in honor of the son of the President of the Court of Appeal, Honorable Justice Monica Bolnan Dongban Mensem. The PDP said that it viewed the frolicking of the governor around the Court of Appeal president, and I quote, with deep suspicion for the fact that the governor is having his election challenged before the Benue State Governorship Election Petitions Tribunal sitting in Makurdi. And of course they went on to say that it's the president of the Court of Appeal who nominates the judges for the panels. PDP was good enough to say that, quote, the party has no reason to doubt the integrity of the president and those judges. But it went on to say that the same cannot be said of the Benue State Governor, and they warned him against any act that may seek to tamper with the course of justice at the Election Petition Tribunal. It's unfair, but that's what happens when judges and lawyers mix. Now, there's no doubt that the sting operation was deeply damaging to the judiciary and inflicted deep scars on the Temple of Justice, although, as I said, all the judges who were eventually charged in the wake of the operation were cleared by the courts. We nonetheless had the embarrassing spectacle of senior lawyers coming forward to explain that huge sums given to some of those accused had been given as personal gifts on the occasion of high society weddings or other such expenses. But as I said, in the end, the government, whether by the DSS or by the Economic and Financial Crimes Commission, was unable to prove any of the charges that it had levied against the judges. Rather, the countercharge that the Buhari administration, its security services, and its Attorney General of the Federation were going after the judges because they had given judgments against the government. That stuck. Here was a case of the executive branch of government inflicting scars on the judiciary. A lasting scar that followed on the heels of the sting operation came with the equally scarring saga of the removal of the Chief Justice of Nigeria, Walter Onnoghen. Onnoghen, it will be recalled, had become the acting Chief Justice of Nigeria upon the retirement of his predecessor in office, but President Buhari had refused to confirm him. As the matter was being stretched past breaking point, it was Vice President Yemi Osinbajo who, as acting president, confirmed Onnoghen as substantive Chief Justice when the president had traveled abroad for medical treatment. However, for whatever reason, the appointment did not sit well with the president or his inner circle, what these days we are obliged to describe as his cabal. And the nation was treated to the sorry spectacle of what one might call a spungo, special purpose NGO, if not an actual gongo, government-owned NGO. It was called the Anti-Corruption and Research-Based Data Initiative, which filed a petition with the Code of Conduct Bureau accusing the CJM of, quote, managing several accounts through which he has been making transfers of local and foreign currencies in a manner inconsistent with financial accuracy. Hauled before the Code of Conduct Tribunal at what, compared to some other cases, seemed like the speed of light, on the 18th of April 2019, the suspended Chief Justice was convicted on 6 counts of non-declaration of assets in respect of 5 accounts between 2009 and 2015, despite subsisting orders from both the National Industrial Court of Nigeria and the Federal High Court that the prosecution at the CCT should be stopped. The Code of Conduct Tribunal ordered his removal from office, barred him from holding public office for 10 years, and ordered the forfeiture of the undeclared assets. Meanwhile, following a recommendation by the National Judicial Council that Onnoghen should be compulsorily retired, he had already resigned on the 5th of April. As I said, those scars were inflicted on the Temple of Justice by the executive arm of government. And I don't need to go into the long list of orders that the executive chooses not to obey. We just saw an example yesterday, which also inflicts scars on the Temple of Justice. But there are others who are also doing their very best to scar the Temple of Justice. I've already mentioned the belief that it's somehow all right for members of the inner bar to mix and socialize with justice. And during the period following the Night of the Long Knives and the raiding of judges' residences, we were treated to unsavory tales about the way that such friendships or intimacy are exploited by some senior lawyers. For example, the SAN, whose juniors would file cases with instructions about the judge to whom such cases should be assigned. More recently, we had the saga of the letter written by counsel in the chambers of the then chairman of the body of benches, Wale Onanipekun SAN, in which it was claimed that cases handled by that chambers received favourable treatment, and that the litigants should therefore terminate their instructions to their existing counsel and bring it over to Chief Onanipekun. In the end, the person who wrote the letter took the rap and declared her resignation from legal practice. Those involved know the actuality of the matter, but there's no doubt that the whole incident inflicted scars on the Temple of Justice. So much for the lawyers, the actual practicing legal practitioners. But what about the rest of those who have business in the Temple of Justice? Let me digress a little. Most, but not all Fridays, I do a short interview with Silverbird Television's News Hub program, in which I give my take on some issue in the news. Week before last, the producer of the program asked whether I would want to discuss the issue of justice delivery and the road to judicial independence. I declined, partly because I'm not always fond of giving an unresearched take on legal matters, no matter how many times they introduced me as, quote, a legal luminary. I'm just an ordinary jobbing lawyer. And partly because I didn't want to preempt anything I might want to say in this lecture. But why I mention it now is because the background to the suggestion that I might want to discuss the matter was a telephone call allegedly made by the Chief Justice of Nigeria to the President. The allegation was that the specific topic of their discussion was the presidential election petitions and the alleged resignation from the judiciary of Justice Bolo Ugo, sorry about the mispronouncing of his name, who was a member of the Presidential Election Petition Tribunal. In a tweet posted by one tweeter, it was alleged that, quote, the judge had written a letter of resignation in which he complained of facing demands to kneecap democracy and being asked to, quote, cripple the independence of the judiciary by ruling in favor of, quote, a certain political candidate believed to be President Bola Tinubu. Went on, Justice Ugo's resignation has caused a serious uproar and a setback to the activities of the Presidential Election Petition Court. That's what this tweeter, Umar Sani, claimed. Incidentally, the claim that the CJN had spoken to the President about the election petitions was also alleged in a tweet by another tweeter. Over the weekend, one tweeter who had previously been arrested under the Cybercrime Act for stalking tweeted this, and I'm quoting, aside from the CJN being notorious for corruption, the likelihood of biased judgment influenced by ethnic sentiment is enough reason to squash the idea of having a president whose shaky mandate is being debated in court and a CJN from the same region. Of course, he deleted the defamatory tweet, but not before it had generated 390 likes and over 200 retweets. These tweets are just the latest in a campaign to denigrate the judiciary that started even before our general elections. And after the results, in which Bola Tinubu was declared the winner, a popular quote that was being circulated by a lot of people who ought to have known better asserted that, quote, whenever a thief encourages you to go to court, just know that his elder brother is the judge. We had the saga of the Chief Justice of Nigeria being photographed in a wheelchair at a foreign airport, on the strength of which, on the 23rd of March this year, an online medium, the People's Gazette, alleged that he had, quote, been sighted in London pretending to be a physically challenged old man, in what Supreme Court sources said was a clandestine preparation for a meeting with President-elect Bola Tinubu. No wonder that in suit number SC.CV 501 of 2023, in which the Supreme Court dismissed the appeal of the People's Democratic Party against the decision of the Court of Appeal, which had in its turn dismissed its appeal over the alleged double nomination of the vice presidential candidate of the All Progressive Congress, Justice John Inyang Okoro, JSC, concluded his concurring judgment as followed. From all I have endeavored to say above, it is seen that this appeal is one of the frivolous appeals that this court has been inundated with in recent times. And in this type of appeal, the promoters resort to social media to set booby traps for the court in order to blackmail it. This is quite unfortunate, and I can only advise the perpetrators of such to desist from such activities. The lead judgment had castigated the case as, quote, a waste of precious judicial time and energy that could have been better expended elsewhere, from the trial court up to the Supreme Court. Now, I'm a lover of word puzzles, so it won't surprise you to learn that just like the president of the Nigerian Bar Association, I found another word to make out of the letters that feature in the words that provide the title of this lecture, scarred and sacred. The word, of course, is scared. At the presentation of Charles Archibald's book on the 15th of February this year, former governor of Cross River State, Donald Duke, asserted that the Supreme Court justices who had delivered the judgment in the Imo State gubernatorial appeal had been denied visas to enter the United States of America for a judges' conference. No doubt he has inside information about the dealings of the United States consular section. Yet in my view, the judgment of the Supreme Court in that case is unimpeachable. And just as we have lawyers to the petitioners at the Presidential Election Petition Tribunal coming out of the court to give news conferences that are almost at 180 degrees to what has just happened before the tribunal, perceptions about that case, the Imo gubernatorial case, are informed by a resolute refusal to look at the case that was presented to the election tribunal by the petitioner and by the respondents, and instead a preference for what, quote, everyone knows, and constant references to, quote, Supreme Court governor, quote, and man who came forth. So, if the US truly decided to withhold a visa from the justice of the Supreme Court because of a decision that they gave in the exercise of their judicial mandate on the basis of the case presented before them, and chose instead to swallow the line that the only reason for that decision was because the judges had perverted the course of justice, that would be their problem. But I ask myself, do I want the chief ministers in the Temple of Justice in Nigeria to give a decision that they know has no basis in law or the evidence presented to them merely because they are scared of not getting a US visa? God forbid. I no more want that than I want them scared because some with face or without faces, people on Twitter or other social media think that they can be frightened. As I said, God forbid.